Hey, Jason Wagner, the farm lawyer. Today I want to talk to you about credit shelter trusts and how they can help protect your farm from Minnesota estate taxes. Watch this video to learn more. Hi, I'm Jason Wagner, the farm lawyer. I work with family farmers every single day to help them pass the farm on to the next generation. At my law firm, Wagner Ayler, we've been doing it for over 50 years. So one thing that comes up almost always with farm estate planning is Minnesota estate tax. And the reason is that the Minnesota estate tax is a $3 million exemption. That means that everybody that has assets that are valued over $3 million is potentially subject to Minnesota estate tax, with the average farm size being over 400 acres and, just use roughly $10,000 an acre. You can see that we get over that $3 million limit pretty quickly. And then you add in, of course, machinery and equipment, livestock, retirement accounts, cash savings, grain in the bins. It can add up. So when you're married, anything you leave to your spouse is subject to what's called the marital deduction. There is no estate tax when you leave assets directly to your spouse. However, you have not used your Minnesota estate tax exemption. And now your spouse has all those assets and only has their $3 million exemption. So sometimes people think, hey, because I'm married, I have a $3 million exemption. My wife has a $3 million exemption. So we can protect up to $6 million of assets from Minnesota estate taxes. But that's not the way it works, because you don't get to just share that exemption amount. You have to design a plan that allows you to use that exemption amount. And as we just said, having everything go to your spouse does not use your exemption amount because it's all marital. It's all subject to the marital deduction. No estate tax, that's great at that first death, but we haven't used the first spouse's exemption limit. So how do we do that? The most common way is that we would establish a revocable trust. So I would establish a trust, my wife would establish a trust, and that trust is going to say, hey, I leave everything to my spouse, but my spouse can also disclaim assets so that they're forced to stay in my trust. Okay? That means my spouse is saying to my executor and to the state of Minnesota, hey, I do not want all of this to be marital property. I don't want to accept it all. I want to keep some of it in my deceased spouse's trust. And then we would look at what is the value of the estate, what is the value of the surviving spouse's estate, what is the estate tax exemption at the time, and how much can we force to stay in that disclaimer trust so that we use the exemption limit of the first spouse to die, but don't trigger any estate tax right away. And so that magic number, of course, right now is $3 million. But it could be more, okay? We also have a family farmland deduction, where if it's farmland going into that credit shelter trust, and it was ag homestead in the year of death, and you owned it for at least 3 years, we potentially can add another $2 million of farmland to that credit shelter trust. So now we're disclaiming $5 million worth of assets and sheltering that from Minnesota estate taxes, now and at the death of the second spouse. It's important to remember that you, of course, can only disclaim what your spouse owns. So if I don't own $5 million worth of assets, my spouse can't disclaim $5 million of assets that otherwise would have come to her. But if I own $5 million worth of farmland and my spouse owns $5 million worth of farmland, it doesn't matter who dies first. Either of us can die first, and we can lock in that estate tax savings with that $5 million exemption. Now, sometimes we would use a formula-funded credit shelter trust. So with a disclaimer, we're kind of punting that decision. We're allowing the surviving spouse to make that decision. And this can make a lot of good sense. If we've got maybe it's a $3 million estate or a $4 million estate, and disclaiming might make sense, or it might not make sense, to put it in that credit shelter trust. Maybe we don't want to have all the extra reporting requirements. We have to file an income tax return every year. We get a stepped up basis at the first death, but anything that goes in that credit shelter trust would not get a stepped up basis at the second death. So we might want a lot more decision-making power at the time of the first spouse to die to decide what we're going to disclaim, or even if we're going to disclaim. But we might also have, let's say, a $20 million farm estate or more. In that case, having a formula-funded credit shelter trust could make sense. So the difference is, we're not saying to the surviving spouse, what do you want to put in your deceased spouse's trust, or what do you want to keep there? Instead, we're saying, hey, trustee, when I die, I want you to give the maximum amount that we can to my credit shelter trust to make sure that I'm using all of my estate tax exemption at the time of my death. Whatever's left goes to my surviving spouse. And in that way, we are sort of shortcutting that decision about funding the credit shelter trust. We can also now give our surviving spouse what's called a limited power of appointment. This is important. This is something you should know about. A limited power of appointment means that my spouse can designate who would actually receive the assets in that formula-funded credit shelter trust upon her death. You can designate, is that going to be descendants, their spouses, charities? But we define that class of who the spouse can appoint to. This can be very helpful when we have a situation where we think we want the farm to go to someone, but we're not quite locked in yet. We want to make sure that our surviving spouse has both estate tax savings and the flexibility to redirect assets if needed. So both a disclaimer-funded credit shelter trust and a formula-funded credit shelter trust have pros and cons. And just like everything with farming, we have to look at your situation. Just like every farm is a little different, every farm estate plan is a little different. So we look at your situation and say, what is the best trust to use? What is the best way to fund a credit shelter trust so that we're saving from estate taxes? But in both situations, the surviving spouse can be the trustee, the surviving spouse can get all the income off of that trust, and if it's really needed, the surviving spouse can pull assets out of that trust if it's necessary for their health, education, maintenance supports, typically the standard. But just knowing that, yes, we have the flexibility, if needed, to pull assets out. But in all cases, most of our plans are going to say the surviving spouse is the trustee, and the surviving spouse gets all of the income. So if it's farmland in that credit shelter trust, rent can come into it, and that rent can come straight back out to the surviving spouse so that they can pay their bills and support their life and decide what to do with that income. So if you're a Minnesota farmer, it's more than likely that you're subject to Minnesota estate tax. There are things you can do to protect your exemption limit so both you and your spouse are getting the full exemption protection, but it's necessary that you work with a farm lawyer to get that set up. And of course, you have to do it now. You can't do it when you need it. So if you like what you hear, follow me on Facebook, subscribe to me on YouTube, and check out farmlawyer.com.